and welcome to the Patent Prosecution Highway webinar. My name is Kim Norwood, and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen, and our technical assistant team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in the listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right side of your screen. Type your question into the text field and hit send. Please keep the send to default as all panelists. This seminar is accredited 1.0 hours of Illinois MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your presenter for today, John Freeman. John, you now have the floor.
My name is John Freeman. I am a shareholder at Brinks, Gilson & Leon. When I first began at Brinks, I handled the prosecution of a large number of foreign patent applications. Also, from time to time, I have been the head of our firm's International Patent Prosecution Practice Group. So with this background, I've been interested in any topic involving the patent prosecution process in other countries. Today's topic, the Patent Prosecution Highway, which I will also refer to as PPH, is unusual in that it can affect both the patent prosecution process in the United States and in some foreign countries. In today's talk, I will try to give you some background regarding the basics of the Patent Prosecution Highway, its evolution over the years, and factors to consider before making a decision on whether to enter the PPH or not. Let's dive into this. So how does patent prosecution of inventions occur throughout most of the world? Typically, an initial utility patent application is filed in a certain country, and one or more corresponding utility applications are filed in other countries just before the one-year anniversary of the initial filing per the Paris Convention. The first filed application has about a one-year head start in the patent prosecution process, and there is a good chance the first filed application will receive an office action before the later filed applications receive a first office action. From this situation, the thought of a streamlined process, later to be called the Patent Prosecution Highway, began to be explored between countries based on the following possible scenario. For example, let's assume that an office action in the first filed application has one or more claims allowed. Such an allowance shows that there is merit in the invention allowed and should be a ticket for the other applications to get in front of the line for prosecution. 2 conditions for getting to the head of the line. Number 1, amend the claims so as to correspond to the claims allowed in the first filed application. And number 2, cite art that was cited in the first filed application along with the office action that indicated there was allowable subject matter. Performing the 2 conditions should accelerate the prosecution process for a later filed patent application. While most countries do not defer to the results in another country, the presentation of claims that were allowed in another country may lead to a greater chance of allowance in another country's patent office. Based on, in large part, on the premise of the expedited process mentioned previously, the United States and Japan constructed the first Patent Prosecution Highway on May 24th 2006. Other highways were constructed subsequently. For example, highways between the United States and Australia, Canada, Denmark, the European Patent Office, and South Korea were constructed in 2008. I'm showing with this slide a typical flow chart for participating in the original version of the PPH. As you can see, originally the first filed application, it should be filed in a PPH participant country, we'll call it Country A, and it could not be a patent cooperation treaty application. Later filed application in other countries, we'll call them B, C, etc., that were PPH participants with Country A and claimed priority to the first filed application in Country A could participate in the PPH if the first filed application received an office action with at least one allowed claim and no office actions received in countries B and C. At this stage, a request for participating in the PPH could be filed for the applications in countries B and C. At this point, I want to emphasize one thing. Participation in the PPH is voluntary. Hopefully this talk will give you some guidance as to whether you should participate in the PPH or not. If it is desired to file a request to enter the PPH, the request would require an amendment so that claims correspond to the allowed claims in the first filed application, and also a disclosure of the office action and the art cited therein should be made in the later filed applications. A certification that the amendment contained a translation of the allowed claims may be required if there's a difference in language. No processing fee was required for the PPH, and if the request is accepted, then the applications in countries B and C, etc., would go to the head of line in their countries. So there are several advantages regarding the original version of PPH. Obviously, prosecution is accelerated by having the application placed first in line for prosecution. Also, a reduction in costs could result, since amending the claims and presenting previously recited art could place the application in a state as if an office action had already been presented. Such a presentation of art should improve the quality of examination, since the amended claims may reduce issues for the examiner to consider, and speaking as a former U.S. patent examiner, the more prior art to consider by an examiner, the better. The PPH process could lead to early issuance if the Patent Office defers to the result of another country. My experience, a prime example of that is Canada. I have found that filing claims that have been allowed in the U.S. have a very good chance of being allowed in Canada, especially if you tell the examiner that these claims have been granted in the U.S. Another advantage is that if a patent is granted expeditiously, it should have a longer time it can be enforced, since the term of a patent is based on the time from filing. By accelerating prosecution in other countries, which could result in better art found in those later filed applications, that's another advantage. Such art could allow the applicant to make earlier decisions on whether to abandon later filed applications and thus reduce costs. There are disadvantages to the original version of the PPH. For example, accelerating examination can mean costs being front-loaded in a manner not desired by the client. PPH depends on allowed claims being found and prosecuting such claims in later filed applications. What if the allowed claims in the initial filed application are too narrow? If you file PPH, you may not be able to broaden or file continuation application with broader claims. So you also must be careful in entering PPH in that claims allowed for certain subject matter may not be patent eligible in another country. For example, methods of medical treatment are allowed in the U.S., but they're not allowed in Canada or the European Patent Office. There are other disadvantages you should consider with the original version of PPH. For example, it's possible that the first office action can come from the later filed applications. You cannot use such an office action to expedite prosecution of the first filed application or other applications. Also, there may be cases where the reasons the claims were allowed in the first filed application are solely because certain references do not qualify as prior art, while the same art would render the same claims unpatentable in another country. Also, you should keep in mind the standards applied by a particular patent office. Some are stricter than others, and so the scope of claims allowed can vary depending on country. I previously discussed the original version of PPH. Let's discuss the current version shown in this slide. Some of the main differences with the original version of PPH are, number one, any application can trigger the possibility of entering PPH. And number two, the first filed application can reap the benefit of entering PPH. Note in this example, the official action for the second later filed application triggers PPH. And so PPH can be requested for the first filed application. That's denoted by the arrow in the box. It cannot be requested in the first later filed application, which is called later filed application number 1 in the slide, since it previously received an office action. The requirements for the current version of PPH are similar to those for the original version of PPH I described previously. Before I dive into those requirements, I want to introduce you to some terms that will be used interchangeably. First, the patent office that renders an office action that contains an allowed claim that can be used to trigger the PPH in another patent office will be called the Office of Earlier Examination, or the OEE. Second, the patent office that enters the PPH based on an allowed claim from an OEE will be called hereafter the Office of Later Examination, or the OLE. With the above definitions in mind, the current version of the PPH requires that the Office of Earlier Examination and the Office of Later Examination have an agreement between themselves to participate in the PPH together. The applications will regard utility applications. PPH does not apply to design, provisional, reissue, reexamination, or plant applications. Also, the PPH does not apply to applications subject to a secrecy order. In addition, the applications in the OEE and the OLE must claim priority to a common earliest priority date. PPH is not available to applications that receive an office action prior to the office action with allowed claims rendered in an OEE. Okay, one interesting change to the current version of the PPH was instituted in 2010. The change was that PCT applications were allowed to be a trigger to enter the PPH in the US, Japan, or the European Patent Office. The condition for the trigger was that the PCT claims priority to the earliest priority application common to the PPH country, and the search/examination authority is either the US, Japan, or European patent offices. Today, this has even been expanded further so that the search/examination authority just has to be a PPH participant. Okay, the present slide presents requirements to have a later examined application filed in the U.S. enter the PPH. In such a case, the PPH is available if the Office of Earlier Examination has an office action with one or more allowed claims that are rendered prior to the mailing of an office action on the merits in the U.S. Now, a a missing parts paper or a restriction requirement in the United States, that would not trigger or not be considered an office action on the merits. A request to enter the PPH in the U.S. needs to be filed. The request must include the office action from the OEE that resulted in the indication of allowed claims and the art cited therein. Okay, one of the interesting things I find about the PPH process is a limitation on claim amendments. The claims must substantially correspond to those in the office of earliest examination. Under U.S. practice, this means that the claims are, one, of the same scope as the allowed claims in the OEE, two, of similar scope as the allowed claims in the OEE, or three, they're narrower than the allowed claims of the OEE. I'm guessing that the second option means that the claims can differ slightly from allowed claims so long as they essentially correspond to the allowed claims. As to the third option, this means that adding dependent claims that were not present in the OEE application is permissible. And now we're at that magic time. It's time to enter your first code, number 1, and it's 2 words. It's patent prosecution. Not persecution, prosecution. Okay, so let's continue. Other requirements for a successful PPH request in the U.S. are, number 1, file a claim correspondence chart showing how the U.S. claims correspond to the allowed claims in the OEE. Number 2, file an IDS with the OEE's office action, which indicated allowable claims, and the references cited in that office action. Note that the request must be filed electronically and does not come with a fee. Upon filing a request in the U.S., you should receive a decision on whether the request has been granted within about 4 months. If your request is denied, you get 1 chance to cure. Let's assume your PPH request is granted. What does that mean? All that means is that your application is put near the front of the line for prosecution. You can still file for extensions of time or perform other actions that may delay prosecution, such as asking for a written restriction requirement. One key thing to keep in mind is that you should not assume that having the request granted will automatically result in the claims in the U.S. application being allowed. The examiner should perform a normal examination of the claims and not give any deference to the previous allowance of the claims by the OEE. It would be interesting, though, to see what happens to the claims if the request is granted near the end of a quarter or fiscal year at the U.S. Patent Office. As you probably know, examiners are under a quota system to complete a certain number of actions during the quarter or fiscal year. A first office action allowance would really help with reaching the examiner's quota, and so an examiner may be tempted to defer to the allowance of the claims presented under the PPH. As mentioned previously, the claims presented at the time of the request are limited in their substance. Such limitations continue after the request is granted. Okay, this slide shows some statistics I put together regarding Korean and Chinese applications pending in 2015, and also Japanese and U.S. applications pending from January 1st of this year to June 30th of this year. I will make a few comments regarding Japan and the U.S. As you can see, for those countries, the data in the parentheses regards the situation when PPH and non-PPH applications are combined in their statistics. So from that, you can see the PPH applications have around a 10% increase in the rate of grant when compared with all applications. Keep in mind that there are other ways to expedite prosecution in the U.S. For example, there are various types of petitions to make special that take into account special circumstances regarding the inventor's state of health, special circumstances regarding the invention, infringement, etc. There are limitations regarding such petitions. Another route is a collaborative search pilot program that involves the U.S., Japan, and South Korea, where there is a sharing of search results. Another route is called accelerated examination. It is an onerous examination in that it requires a search and comments by the applicant on the art and how claims are distinguishable over the art. Lots of minefields here due to estoppel are present, so I usually recommend that you don't enter such an examination. Another route is to look at is track one. Here you have to pay a fee of around $4,000 to get to the front of the line without many of the accelerated examination burdens. You should be aware that other countries have ways to expedite prosecution as well. Here I've just listed a few for Australia, Canada, Europe, United Kingdom, Japan, South Korea. And as far as I know, China doesn't let you expedite prosecution. So the PPH appears to be the only way to get expedited prosecution there. So where do things stand today? PPH has really grown in popularity throughout the world. Two major pilot PPH programs were established in 2014. They're called IP5 and Global PPH. Each represents a certain number of participant patent offices, wherein the U.S. is a member of each. Each group has similar requirements to enter PPH. Under the IP5 and Global PPH programs, allowed claims in PCTs can trigger availability of the PPH, so long as the PPH member is a search authority or an examining authority. This slide shows the members of IP5: China, EPO, Japan, South Korea, and the U.S. They handle about 90% of all patent work in the world. This slide gives you 20 members of Global PPH, not counting the U.S. This slide shows some of the properties of IP5 and Global PPH that provide much flexibility in entering PPH in the U.S. and other countries. In this slide, I'm showing you that the U.S. has PPH agreements with other countries outside IP5 and Global PPH. And with that said, we have time for entering another code. Number 2, it's November webinar. Okay, so let's move on. So we've had enough of the requirements for entering the PPH in the U.S. and elsewhere. Let's look at various examples. This slide shows a standard way to enter the PPH in the U.S. based on a foreign filing. So as you can see, the foreign filing was done first. After that, the U.S. claim priority was filed. After the U.S. was filed, we have an office action in the OEE, which had allowed claims, and based on that, you have the option at that point to enter the PPH as long as the U.S. and the OEE are PPH members. So here's one that just shows the PPH where you can enter in multiple countries. Here's a situation where you can opt for the PPH in one country and not in other countries. So in this case, we've opted for PPH in country A, but we're not opting in the U.S. Maybe the claims are, we think, too narrow for the U.S. If you opt for the PPH in the U.S. application, you are not required to request PPH for other applications in the U.S. chain. Indeed, another U.S. application probably would not be allowed to enter the PPH since, due to restrictions on claim practice, it may lead to having the same claims in multiple applications. Because remember, one of the requirements is that the claims in the application must be substantially the same as in the OEE. Okay, here's an example where a PCT application is the trigger for the PPH. Here, what we're calling a favorite determination, we're calling it FD, has occurred in the PCT. That means that there's been favorable indication in the search report, a written opinion, a written opinion or some kind of examination report. And based on that paper, you can go into other countries via the PPH. Here's an example where the PCT is downstream in the priority chain. But again, the PCT is triggering or allowing you to get into the PPH. Okay, the next two slides are showing examples where the U.S. application is a 371 filing based off of a PCT. Okay, in this slide, this shows a situation where the U.S. does not need to be a 371 filing in order to use a PCT determination to request PPH. Okay, in this slide, we have a later filed PCT, can be used to request PPH for a first filed U.S. application. Okay, one thing to keep in mind is you're very lucky for the United States filings because the U.S. has a very liberal continuation practice, makes it less onerous to use the PPH. Here you have one application with the claims limited to the OEE allowed claims. And you file other continuations to pursue other inventions and or broader coverage. So in this one, U.S. application number 2 is going to have narrower claims than what are filed in U.S. application number 1. But you can prosecute both simultaneously. Okay, this slide gives you an example where the OEE is the U.S. application and you file the PPH in non-U.S. countries. Okay, the next two slides are going to show you where show that the request for PPH must be based on an office action of a patent office that is part of a PPH agreement. So in this slide that's shown right now, the later filed application number 1 is a non-PPH country or patent office. It's received an office action with a allowed claim, and by the cross, meaning you cannot use PPH. They're just not common members of the PPH. But if that same country was a PPH member, then that office action would allow you to request PPH in the later filed application number 2. Okay, well, I'm near the end of my talk. And so what I have here is a flow chart that gives you a possible decision process to determine how to use the PPH process. I'll go through the chart step by step. First, you need an application that has an allowed claim from an office action, as we've stated many times before. Okay, the first thing to ask is whether the claim is adequate in scope. If not, just continue prosecution in that OEE application and do not implement PPH in the other countries. If there is an adequate claim, then things get interesting. First, amend the claims to get a patent with the OEE application. Second, ask whether the allowed claims would be patentable in other related applications, taking into account the prior art and the invention involved. If it would be patentable, then ask yourself whether the applicant wishes to expedite prosecution. If the answer is no, you can still consider amending the claims of other applications. You're just not going to get ahead of the line. But if the answer is yes, you should investigate all avenues for expediting prosecution in other countries, including the PPH. Okay, this slide gives you some other factors to consider before using the PPH. For example, if the allowed claims of the OEE are sufficiently broad, I think you should seriously consider using the PPH throughout all your related applications. However, if the allowed claims of the OEE are too narrow, I would only consider a PPH if there's an infringer of those claims in a PPH country. Also, remember, it's not the end of the world. All it means is that prosecution will not be on a fast track. Also, be aware of how strict the OEE is when allowing claims. The stricter a country is, the more confidence you have that the breadth of the allowed claims is appropriate. Be aware of how countries treat art and inventions differently before making a decision on using a PPH. In the U.S., consider requesting PPH so claims examined near the end of the quarter or fiscal year. You could call the examiner before the end of a quarter or the fiscal year and alert that examiner that there is a PPH application on his or her docket. And for some examiners, that might be enough to get a notice of allowance for that case. Okay, one last thing I'd like to talk about, and this is just a proposed tweaking of the present version of the PPH. And that is, why not eliminate the requirement that the claims in the OLE, the later examined application, be substantially the same as those in the OEE? Now, currently the examiners still will do a normal search no matter if it's a allowed claim from a previous application or not. So why not have the examiner examine claims you believe are patentable, not the OEE? The key is that a patent office has found an allowable claim matter. And that by itself, I think, should be sufficient reason to get on a fast track. And then let you prosecute the claims as you would like to from that point. I think that such a tweaking of the system would lead to a tremendous use of the PPH. And so hopefully one day such a system will come into play. So that's the end of my talk. Does anyone have any questions? And I'm looking at my board, and I've again done a brilliant job. I cannot find any questions from you. But you will get a copy of this presentation, and sometimes you might think of a question later on. So feel free to email me any of your questions, and I'll be happy to answer them for you. So with that, I'm going to conclude this program.
Thank you for your participation. That concludes today's call.